All right, this is case number 254059 SM, the people of the state of Michigan versus Brendan David Lee Russell. Appearances, counsel?
Courtney Lawrence on behalf of the people.
And I'm Jeff Harrison. I'm here on behalf of Mr. Russell. He's next to me at the table, court with us today.
We are here for a final pretrial. Is there any resolution in this matter?
There is, Your Honor.
It's my understanding the defendant will plead guilty as charged. There is also an agreement for sentencing under HIDA.
That is correct, Your Honor.
All right. Mr. Russell, have you heard what the attorneys have said the resolution to this case is?
Yes, Your Honor.
And is that how you wish to resolve it?
Yes.
Will you please raise your right hand? Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I swear.
So it's my understanding that you'll be pleading guilty as charged to retail fraud third degree. That is a misdemeanor punishable by up to 93 days in jail and or a fine of $500 or three times the value of the property taken, whichever is greater. In exchange for that, the people have agreed to a Killebrew agreement. Killebrew just references a case, but what's important to that is that's a sentencing agreement. And that agreement is that you would be sentenced pursuant to the Holmes Youthful Trainee Act. If you're successful with that period of probation that I would put you on, the charge would be removed from your record. If you're not successful, it would show on your public record. Do you understand that?
Yes, Your Honor.
Either way, it's going to show on your law enforcement record, just not your public record. Now, do you also understand that that's an agreement you have with the prosecutor? That's not an agreement you have with me. So if I decide that I'm not going to follow that agreement, you would be able to withdraw your plea. Do you understand that?
Yes, Your Honor.
Back on September 12th, were you on probation or parole?
Yes, Your Honor.
Was there a probation violation done in regards to this?
Yes, Your Honor.
All right. Do you remember reading and signing the advice of rights form? It talked about your rights to an attorney and your rights to a trial.
Yes.
Did you understand those rights?
Yes.
Most importantly, do you understand that you have a right to a jury trial and that by entering a guilty plea today, you'll be giving up that right and you won't have a trial of any kind?
Yes, Your Honor.
Has anybody promised you anything in order to get you to plea today other than the plea agreement?
No, Your Honor.
Has anybody threatened you in any way?
No.
And is it your own free choice to plea today?
Yes, Your Honor.
Are counsel aware of any other promises, threats, or inducements not made part of the record? Then, Mr. Russell, to the allegation that on or about September 12th, 2025 in Herion Township, Wexford County, how do you plead to retail fraud third degree?
Guilty, Your Honor.
In order to accept that plea, I must have you tell me what it is that makes you guilty. So it looks like back on September 12th, you were in the Herion Township Meyer store. Is that accurate?
Yes, Your Honor.
And while you were there, did you either steal or attempt to steal property that belonged to the store?
Yes, Your Honor.
And do you agree that that had a value of less than $200?
Yes, Your Honor.
What is it that you took?
The hoodie and a bottle of
All right. Did you
Bloody
actually?
Mary mix.
I'm sorry.
Bloody Mary mix.
All right. And did you actually get out of the store with that?
No, Your Honor.
Where were you stopped at?
20 foot before the doors, 30 foot.
Had you passed the cash registers?
Yes, Your Honor.
All right. And was it your intent to take the property without paying
Yes,
for it? You counsel believe that the defendants provided a factual basis to accept the plea and that the court rule has been complied with?
Yes.
I do as well.
As does the court. I find the plea is knowing, voluntary, and accurate. The court will, I believe, based on the defendant's prior history, will sentence the defendant pursuant to HIDA. So I therefore, yeah, I'll take the plea under advisement. Any allocution, Mr. Harrison?
Your Honor, this is the very definition of an extremely poor decision made by a young person who is experiencing some degree of stress in his life. Pardon me. And was not thinking clearly in terms of the ramifications of his behavior on that night. I have beat him up about this. He has beaten himself up about this. His mother, who's present with him here today, pardon me, this follows very closely with, as you noted, he was on probation at the time for an incident in which he lost his temper regarding his mother just trying to be his mother and enforce the rules of the household. In other words, I think if you took a snapshot of this part of Brennan's life, you would say, this guy needs to grow up a little bit. I'm happy to know that I think he has. I've continued to talk with him about situations like this where on one hand, it's like a lot of people, or it's almost at one point in time, it was almost considered a rite of passage to steal something from a store, get away with it. And that sort of behavior just is not even tolerated anymore in the way it might have been, I don't know, 30, 40 years ago. I don't want to date myself too much. He's aware of that. He's aware of that because he is a taller guy. He's going to stick out in the crowd more often than not. And he has a responsibility to himself to get his life on track. And I'm pleased with his responses to me with regard to that discussion we had even a little bit more here today, that I think this was an act of stupidity, a very poor decision executed under very trying circumstances. And he's more than learned his lesson, particularly with regard to potential incarceration. Now, you should note, Your Honor, as a result of that probation violation, he is doing weekends in jail in Missaukee. That would dovetail nicely if you wanted to incarcerate him. If the thought was you wanted to reinforce the idea that breaking the law is breaking the law, I don't know that it's necessary here, but I wanted you to know that the reason he's serving the weekend time is that he's full-time, gainfully employed. Obviously, that's very important to him, especially at this age, to have a job, have a steady job, and create sort of a work history as he moves forward into older adulthood. I'm heartened by the fact that the court considers him a good candidate for HIDA. I do too. You should note he has 4A on his prior probation. That's why he's doing the jail, so that he does not lose that 4A status. These are two very close calls based on two, I believe, isolated instances of a terrible decision. And these are the circumstances that he faces. So I appreciate, and so does he, the gift that's been given to him through the 4A and the proposed grant of HIDA here, which would keep this off of his record in case he ever wants to go to work in a store or something like that, where they would check his record, they'd do a background check, and they wouldn't see an act of stupidity, they'd see somebody who was a thief. And that's the point that really drove it home for him. So I would say if we can conform with his probation that he's on now, which expires in March. Okay, if that's at all possible, to earn the HIDA, which I think it's appropriate that he earn that, and allow him the closure that's afforded to him by virtue of the HIDA. Thank you.
Thank you, Ms. Lawrence.
Thank you, Your Honor. I do think Mr. Russell is a good candidate for HIDA as well. Some of the statements he made to officers were a little bit concerning in the police report. He had told them he had been going through a lot at home. He had no one to talk to, and he decided to steal the alcohol to distract himself. So that does cause people some concern. Given Mr. Russell's age, we do not want to see him back here. So I do think a short term of probation would be appropriate, given the facts of this case.
Is there any restitution requested?
I believe everything was recovered. Is that accurate? Okay.
Mr. Russell, you have the right to address the court prior to sentencing. Is there anything you'd like me to know?
I'm sorry. I won't have it again.
So you're 19, if I do my math correctly? You're 19 years old and now have 2 misdemeanor convictions on your record. And this event happened the very day after you were placed on probation for the foray.
Yes, sir.
So what was going on? I mean, obviously there were some issues at home, as Mr. Harrison alluded to, and with the conviction, but what's going on?
Not to call out my mother, Your Honor, but she disappeared and I was quite worried about her. I didn't know where she was or when or if she was coming home.
So how much jail did Judge Ransom sentence you to for this violation?
10 days worth, Your Honor.
And so you're serving that on the weekends.
Yes, Your Honor.
Did she extend your probation at all, or did she keep you on track?
I'm not sure, Your Honor.
All right, the lien shows that you're supposed to be off in March. So what are you doing for probation over in Missaukee County?
Random testing, show up whenever she wants me there, whatever they want, honestly.
Okay. Did your testing get increased after this incident?
Not that I know of, Your Honor.
Because you were only on for one day.
I've still been on random testing.
Is alcohol an issue for you?
No, Your Honor. If I would have got it, it probably would have been.
What do you mean by that?
I would drink and for excuse, I'd rather not, Your Honor.
Do you have a problem with alcohol?
No, Your Honor.
Well, as I said, I am going to sentence under the HIDA. Might question why that is, given that you were on probation and committed another offense, but you probably hadn't even had your first report date. So I realize that probation didn't have an opportunity to work with you before this conviction arose. So that's why I'm going along with the HIDA agreement in this case. I'm going to put you on probation for a period of, just double check something. I'm going to put you on a period of probation for 4 months. That should be pretty close as to when you're going to run out of probation on your other Missaukee County file.
Okay,
All right.
so it runs along with.
It's going to run along with it, or as close to along with it as possible. You might have to have a couple more days on this case than you would the other case.
Okay.
During that time, you're not to violate any law, report as ordered, not leave the state without permission of your probation officer, keep your contact and employment information current. And because this is HIDA, you are not eligible for early release, so you'll have to serve that full 4 months probation. These are probably going to be duplicative conditions, just so you're aware,
Okay.
because I'm also going to order that you not consume any alcohol. I'm also ordering no illegal drugs and no recreational marijuana.
Yes,
And you'll be subject to testing at the condition of your probation officer. I'm going to order a retail fraud class or shoplifting class. And any additional programming that your probation officer thinks is appropriate.
yes, Your Honor.
There is a $75 Crime Victims' Rights Fund fee, $50 state minimum fee, $150 fine. I'll waive court costs and attorney fees. I'm also going to waive the probation fees because I don't want to double hit you for the cost of probation. All
Thank
right.
you, Your Honor.
Now, because you, in theory, are going to get a benefit from society, society is going to let this, if you do everything we've asked you to do, is not going to let this conviction show on your record. So to pay society back, I'm going to order that you do 14 days worth of community service work. All
Yes,
right.
Your Honor.
You did not sit any jail on this case at all, right? For this case, you may have sat it for Missaukee, but not for us.
No, Your Honor.
All right, so there'll be 0 days jail with 0 days credit. And now any balance that remains unpaid for more than 56 days is going to have a 20% penalty added to it, but I'm going to waive that penalty for the time that you're on probation. So that 56 days will start clicking after you finish probation if you haven't paid it by then. Does that make sense?
Yes, and where do I pay them, Your Honor?
You'll pay that here.
Okay.
Yeah. Mr. Harrison, you had a quizzical look on your face. Was there? Besides your normal look.
I was thinking of something else that I need to ask him.
Okay, all right,
It doesn't pertain to the current discussion.
all right. Mr. Russell, do you have any questions for me about your sentence?
Thank you, Your Honor.
All right. Hopefully it works out. Hopefully you can get whatever's going on under control, and I don't want you to forget about what happened, but I don't want it to hold you back either. So just do what you need to do, get this off your record and move forward from it. You can go out to the front window where you checked in, get a copy of your judgment, make a payment if you're able to. If you're not, get set up on a payment plan. And then you'll go downstairs to district court probation and get signed up for probation.
Thank you.
All right, thank you. All right, court calls the people of the state of Michigan versus Stephanie Rochelle Pink.
To count one, nope, I apologize, to count two, operating while intoxicated, and the people will be dismissing count one, operating with a high PAC.
Mr. Hertel.
That is accurate, Your Honor.
Mr. Williams, have you heard what the attorneys have said the resolution in this case is?
Yes, sir.
And is that how you wish to resolve it?
Yes, sir.
Will you please raise your right hand? Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
It's my understanding you'll be pleading guilty to count number 2 of operating while intoxicated. That is a misdemeanor punishable by up to 93 days in jail and or a fine of $100 to $500 and or 360 hours of community service, rehabilitative programs, possible vehicle mobilization, and reimbursement for governmental expenses. In exchange for that, the people will be dismissing count number 1 of operating with a high BAC. That is a 180-day misdemeanor and fines of $200 to $700. Now, do you understand that the prosecution would only be able to move forward on one of those charges if they were to take you to trial? They couldn't try you on both. Do you understand that?
Yes.
So they would have to choose either the high BAC or the OWI to take you to trial on. Does that have any influence on your decision to plead today?
No, Your Honor.
Other than the plea agreement, has anybody promised you anything in order to get you to plead today?
No,
Has anybody threatened you in any way?
no.
And is it your own free choice to plead today?
Yes.
Are counsel aware of any other promises, threats, inducements not made part of the record?
Oh, yeah.
Your Honor.
Mr. Williams, back on September 6th of this year, were you on probation or parole?
No, Your Honor.
Were you on bond?
No.
Do you remember reading and signing the advice of rights form, talk about your rights to an attorney and your rights to a trial?
Yes, Your Honor.
Did you understand those rights?
Yes.
Most importantly, do you understand that you have a right to a jury trial and that by entering a guilty plea today, you'll be giving up that right and you won't have a trial of any kind?
Yes, Your Honor.
Then to the allegation that on or about September 6th, 2025 in the city of Cadillac, Westford County, how do you plead to operating while intoxicated?
Guilty.
In order to accept that plea, I must have you tell me what it is that makes you guilty. So back on September 6th, were you operating a motor vehicle in the city of Cadillac?
Yes, Your Honor.
And prior to operating that vehicle, had you consumed alcohol?
Yes, Your Honor.
How much had you had to drink?
More than legal limit.
What were you drinking? Beer,
Yeah,
liquor,
it was
combination
a
of
little liquor, a
everything?
little beer.
All right. Ms. Lawrence, is there a chemical test to support the plea?
The intoxilizer was used in this case and it came back at a .172 and a .171.
You would stipulate, Your Honor.
All right. Do counsel believe the defendants provided a factual basis in which to accept the plea and that the court rules have been complied with?
Yes.
Yes, Your Honor.
As does the court, I find the plea is knowing, voluntary, and accurate. Mr. Williams, I find you guilty of operating while intoxicated pursuant to the plea agreement. The operating with a high BAC will be dismissed at the time of sentencing. Counsel, I know there's a substance use assessment, but that was not provided to the court timely to review it prior to taking the bench, and we have a full docket this afternoon, so we'll set this for sentencing. Mr. Williams, I'll need you to go out to the front window where you checked in and get your next court date for sentencing. Just a reminder that your bond conditions continue.
Okay,
All right,
thank you.
thank you.
Robert Hartzell from Mr. Hardy, who joins me at the table, Your Honor.
And we are here for a final pretrial. Is there any resolution in this matter?
There is none, Your Honor.
All right. So we are currently set for December 19th as our trial dates. Mr. Hardy, I just want to make sure that you're aware as to what happens from moving forward from here. The only things that can happen at this point is because today is the last day, I will accept a plea unless it's a plea is charged. So either the case is dismissed, it goes to trial, or you plea is charged. That's what happens from here on out. Do you understand that?
Yes, I do.
Have you had adequate opportunity to discuss all the issues with your attorney and to make an informed decision today?
Yes.
All right. Ms. Lawrence, are you aware of any issues that would prohibit this from going to trial on the 19th? Mr. Hartel? All right. We will set it then for trial on the 19th. I know we already have one scheduled then, so it's possible things will move around, but we'll figure that out as we get closer. Mr. Hardy, you can go out to the front window where you checked in and get your next court date.
So it's not the 19th?
Yes.
All right, thank you. Get over my office.
And we are here for a final pretrial. Is there any resolution in this case?
Your Honor, it's my understanding that defendant will be pleading guilty to an added count of domestic violence with people supporting sentencing under 4A.
Guilty or no contest?
Yes, Your Honor, I'm sorry, it's no contest to domestic violence with 4A. It's a kill root of 4A, and the reason for the no contest plea is there is an ongoing matter with CPS.
Mr. Hartel?
That is accurate, Your Honor.
Ms. Pink, have you heard what the attorneys have said the resolution in this case is?
I have, Your Honor.
And is that how you wish to resolve it?
Yes, sir.
All right, will you please raise your right hand? Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Ma'am, it's my understanding you'll be pleading no contest to count number 2, which is domestic violence. That is a misdemeanor punishable by up to 93 days in jail and or a fine of $500. In exchange for that, the people will be dismissing count number 1 of child abuse 4th degree. That is a 1-year misdemeanor or probation for up to 5 years. Additionally, there is an agreement with the prosecutor that you would be sentenced to under 4A. And that makes reference to the statute. And what that means is that I put you on a period of probation. As long as you're successful with that probationary period, the charge would not show on your public record. It will show on your law enforcement record. If you're not successful, the court could enter that conviction and that would show on your public record. Do you understand that? You also understand that that's an agreement you have with the prosecutor, not an agreement you have with me. So if I decide that I'm not going to follow that agreement, you would be able to withdraw your plea. Do you understand that? Back on August 22nd of this year, were you on probation or parole?
No.
Were you on bond? Do you remember reading and signing the advice and rights form, talk about your rights to a trial and your rights to an attorney?
Yes, sir.
Most importantly, do you understand that you have a right to a jury trial and that by entering a guilty plea today, you'll be giving up that right and you won't have a trial of any kind? Other than the plea agreement, has anybody promised you anything in order to get you to plea today? Anybody threatened you in any way? And is it your own free choice to plead today? Are counsel aware of any other promises, threats, or inducements not made part of the record?
No, Your Honor. No, Your Honor.
I should have also said that the no contest plea would allow the court to review a police report to determine whether or not there's a factual basis and to be able to use that for sentencing purposes. The no contest plea means that you accept responsibility without saying you're guilty. And the reason for that no contest plea would be to the ongoing CPS matter. Do you understand that as well? And that's the allegation that on or about August 22nd, 2025 in the village of Nissick, Wexford County. How do you plead to count 2 domestic violence? Counsel, I had been advised of the plea before taking the bench and had been provided with Wexford County Sheriff's Department case number 83-2501537 that has now been marked as People's Exhibit number 1. Mr. Carnes, are you moving for its admission?
Yes, Your Honor.
Mr. Hartel?
As am I, Your Honor.
People's 1 is received. As I mentioned prior to taking the bench, I had reviewed the police report. Counsel, do you believe it forms a factual basis in which to accept the plea and the court rule has been complied with?
Yes, Your Honor.
Yes, Your Honor.
As does the court, I find the plea is knowing, voluntary, and accurate. As such, I find Ms. Pink guilty of domestic violence In particular, I find based on my reading of People's Exhibit number 1, that back on August 22nd, 2025, Ms. Pink's stepson had left the house without permission. She locates him. He refuses to come back with her. There's some scuffling back and forth, and she eventually puts her arm loosely around his neck in kind of a headlock, trying to get him to stop fleeing. Somehow he gets away. He goes to the quick lube, and law enforcement is called at that point. Also, the domestic violence sheet attached to Exhibit 1 indicates that they were residents of the same household. I also find that the interests of justice are well served in allowing the defendant to enter a no contest plea due to the potential liability of the CPS investigation or case. Are we able to sentence today, Mr. Carnes?
Yes, Your Honor.
Mr. Hartel, any objection?
No objection.
Mr. Hartel, I see that you'd filed a mitigation report. For whatever reason, I didn't see that before now, so give me just a moment to review that. Mr. Carnes, have you received that?
I have, Your Honor.
All right, Mr. Hartel, any allocution? Well, first of all, Mr. Carnes, is there any written input?
There is not, Your Honor.
All right, allocution, Mr. Hartel?
Yes, Your Honor, I would ask the court to adopt the Killebrew. I do believe this would be a fair resolution. I'll avoid overly allocating due to the purpose of the no contest, as the court did note. But just the court is aware, she does have quite a bit of moral support. Obviously, some people wrote letters of support, as you just read. Some people are in the courtroom today. Others have volunteered to provide additional letters of support, albeit hopefully it'll be a moot point here in a moment. But if I understand correctly, the goal is reunification, and I'll simplify it that way. I do believe that will take many steps beyond what this court's doing. I won't get into the other court stuff because that's not what we're doing here. But I do believe this is something that will not be back before this court again. I believe my client will complete this term of probation successfully. I believe she's highly motivated, not only to get the benefit of the delay if the court does grant it, but in general, she doesn't want any of these type of things to reoccur. Blanket statements. I shouldn't say anything more than that for no contest. Thank you, Your Honor.
Thank you, Mr. Carnes.
Thank you, Your Honor. This incident is troubling. I noted particularly multiple witnesses, or at least one witness observing her punching the victim in the head with a closed fist. That being said, I did review the mitigation report and the letters of support. I'm sure this is one of Ms. Pink's worst incidents. And I do think that sentencing under 4A is appropriate. I did note there was a one prior matter in 2007, but I discussed that with defense, and I was assured that was not a violent incident. So I do think sentencing under 4A is appropriate. I'd ask the court to follow the killer. Thank you.
Thank you. Ms. Pink, I realize you entered a no contest plea, but you do have the right to address the court. Is there anything you'd like me to know?
No.
Are you working services with CPS at all?
We have a reunification worker that we're working with.
How's that going?
Well, up until today, slowly, because we had to know what was happening in court first.
Okay, fair enough. And I do see the incident that Mr. Carnes was talking about. It looks like that was what, about 18 years ago, 18 years ago, if I do my math correctly. So I do find the defendant is a good candidate for treatment under 4A, so I will follow the recommendation. Ms. Pink, while you're on for a sentencing, I'm going to put you on for a period of 12 months. During that time, you're not to violate any law. Report is ordered, not leave the state without permission from your probation officer, and keep your contact and employment information current. Because this is 4A, you are not eligible for early release. So you'll have to serve that full 12 months in order to get the benefit. During the period of time that you are on probation, I'm going to order that you comply with CPS, that you attend any programming that your probation officer feels is appropriate. And I'm also going to order that you do 14 days of community service work. There is a $75 crime victim right fund fee, $50 state minimum fee, $150 fine, $150 court costs, $150 attorney fee. 12 months of probation is $360. And you did not have any jail on this case, right? All right, so 0 days jail, 0 days credit. Any balance that remains unpaid for more than 56 days will have a 20% penalty assessed to that, but I'm going to withhold that penalty until after you've completed your probation. So if you get this paid off during the period of probation, you won't have the penalty added. So that 56 days will start ticking after you're done with probation. All right. Mr. Carnes, I know there's a no contact order in place. Thoughts on that?
Your Honor, the victim's father wants it lifted. And other people take no position.
I will lift the no contact order as well. I am going to add that you not act in any threatening, intimidating, or harassing behavior. All right, you can go out to the front window where you checked in, get a copy of your judgment, make a payment if you're able to. If not, get set up on a payment plan, and then go downstairs to district court probation and get set up for probation. All right, thank you. Good luck.